Hi, this is Anthony Parent of IRSMedic. I am on vacation in beautiful Naples, Florida right now, but there was a big case coming out yesterday that I just had to get interrupted and talk to my good friends John and Keith about it. It was the Bittner decision. It came out. We discussed this in a previous podcast. We were wondering how the Supreme Court was going to rule, if they were going to rule for a $40,000 penalty for Mr. Bittner or a $4.2 million penalty. Well, good news for Mr. Bittner, it's $40,000, if you want to call that good news. Now, here's the thing that every business owner, and this is really our concern because we think there's so much confusion about this. What every business and owner needs to know, and even people who work at businesses, that if you have signatory authority over for a bank account over $10,000 in the aggregate, you likely have to file an FBAR. Again, it might not be your account. It could be an account you're managing for someone or managing for your boss or managing for a client. You have to file it because here's the thing you need to understand. The very same penalty regime applies to you, whether you own the account or just are a signatory. And if you look at these penalties, they're a little nutty. Now on Bittner, we could see that, yeah, the IRS wanted to assess $4.2 million because he didn't file a piece of paper. Now the Supreme Court held again, like, no, the $10,000 penalty for the non-willful assessment is on a per form basis, not a per account basis. So the Supreme Court, fortunately for Mr. Bittner, said it was a $10,000 non-willful penalty on a per form basis, resulting in a huge drop in what Mr. Bittner will have to pay to get out of this. But here's the question I have for our viewers and for everybody around. Is this case really a victory for taxpayers? Well, actually, you know who I could think could really help us answer this question? John Richardson, the great John Richardson. John, is Bittner a great case for taxpayers, or is something else going on?
Well, it's a great case for Mr. Bittner and deserves congratulations for his perseverance and ultimately his victory in his case. No, I don't think this is a good case for taxpayers generally at all. I mean, first of all, there's no doubt that the profile of the Bittner case is definitely going to raise awareness of FBAR, I think, generally. And I think it's going to be a lot easier for the IRS to say, well, come on, I mean, don't you read the news, et cetera? I mean, you know, FBAR is gradually creeping, not from sort of an obscure thing, from, you know, an important household name. I mean, sooner or later, people will sit down for dinner and talk about FBAR and FBAR penalties. But I think what needs to be understood, and also on the second thing is this, that in its essence, what the decision did was limited the penalties the IRS can impose in a civil non-willful case to the form itself, which is $10,000, and that's not going to be enough for the IRS, right?
No.
The obvious workaround is, well, you know, let's forget there's nobody who, you know, it's sort of like you know, Ronald Reagan once describing his marriage, and he said, you know, when Nancy and I got married, we, you know, made a decision that I'd make all the big decisions and she'd make all the small decisions. And, you know, in all our years of marriage, we've never had a big decision. Right. And, you know, you know, transferring that over to here, there will be no more non-willful FBAR penalties. You know, everything's going to become a willful penalty, and willfulness is, of course, a question of fact. And, you know, people better, you know, make sure that's determined by the courts. But the bottom line is that I think that there's likely to be a trend towards more and more FBAR penalties. And I think that anybody who has anything to do with any non-U.S. account of any kind, and that's more than a bank account, it's a brokerage account, certain insurance policies, perhaps. I mean, it really depends on the characteristics of what you have where you are. It needs to be very, very careful about this because I think that you know, first of all, I think they're more likely to allege willfulness. The case law to date has defined willfulness in rather a sort of a loosey-goosey way.
Mm-hmm.
So people have got to be careful. And a very good example of this, and we may have talked about this, is the recent Molyneux case, right? Where this woman who was living in New York had signature authority over some accounts in France. They were not her accounts at all. They were not her accounts, but she did have signatory authority. And the bottom line is the IRS imposed a willful FBAR penalty of $200,000 in each of 2 years. But the interesting point is that the value of the accounts was far less than $200,000 in any of the years. So, I mean, let's look at what's happening to this person. So she has signatory authority over a business account. That is not her account. The amounts in the accounts, I think the maximum balances in the two accounts were like $29,000, $69,000. The IRS asserted the willfulness to enable the IRS to assert a penalty of $100,000 on each of the two accounts. Now, look, $100,000 penalty, $29,000 balance in an account that's not even yours, right? So,
well, and this is where I want to interrupt. How do you pay for it? You don't have the money. It wasn't your money, and now they're
you got a small business loan. You got a small business.
There you go. Take out. Yeah, right there. You go. Go to debt to pay your FBAR. There you go.
Pay FBAR penalties. Yeah. Anyway, I mean, they're more abstract and sort of legal analysis reasons why I think the Bittner FBAR decision is perhaps not going to turn out too well. I'll share one of them, and that is that only 2 of the 9 justices who heard the case were willing to consider anything beyond what the statute actually said. It was all about the interpretation of the statute itself, nothing to do with other issues like excessive fines clause or, I mean, what do you think about having a statute where it's not clear what people are required to do? These sorts of things. Even in the majority, which was 5 judges, 3 of the 5 judges would not join Justice Gorsuch in opening the door on looking at FBAR penalties more generally. So I think that decision is going to be a strong endorsement of the principle that the U.S. government can do anything it wants. Our job as the court is only just to make sure the statute is clear on what's prohibited. That's it.
Wow. And John, you wrote a fantastic article about that. And I'll just share that. And before I'll just share that link. I'll bring up that right here. John wrote an article. I'll give the link to that in the description below. John really has some great, if you want to get into really the great analysis of it and why it is, I think this Bittner decision, while it was a victory for Mr. Bittner, it's going to be used as a sword by the IRS. I want to ask a question of Keith right now. Keith, you talk to business owners, people around the world about their issues, and this is sort of my concern as an employer myself. Have I checked to make sure that I have employees on signatory accounts? However, they're all domestic. So the concern, this is the thing I wonder. Is business owners around the world, have they gone and do you think any of them are actually looking to say, hey, wait, I got to make sure that my employees are protected. The last thing I want is one of my employees or someone who's working for me to be punished incredibly. And I think that what John's point is, like, we can basically kiss goodbye to the non-willful penalty at this point. Because why is the IRS going to put all this effort into it? No. We could kiss goodbye, and they are so loosey-goosey with the facts, and they make up things left and right, and they make up the law left and right. And the Supreme Court obviously can't read the statute because the statute actually says there's only the Secretary of Treasury shall be required to create a form for foreign agent reporting, which is specifically not foreign bank accounts. So if the Supreme Court actually just read the statute, there'd be no FBAR penalties against individuals because it's only for foreign agent reporting. The question I have is, though, do you think there is any sort of concern by business owners that they're filing FBARs on their signatory authorities, anything that they may have signatory authority on, not just a beneficial owner, but their employees? What are they doing? Anything? Are they taking any actions to make sure it's all done right?
I think, for me, and it's just based on my experience and the people with whom I've spoken who have businesses and so forth, I don't think there is a concern because they don't know that if they have an American who has signatory authority over the business account, that's what they need to do. They just don't know. It just doesn't enter their sphere of thinking. That's what I would
say this, right? I mean, if I was an employee I'm an employee working in the great state of Florida, right? And I'm working, and I have a bunch of accounts overseas that I'm the custodian of. I'm like, okay, yep, I have all these accounts. I'm working for a place. I never file an FBAR, for the
Right.
signatory.
Okay.
Next thing I know, I get a $4.2 million, penalty against me. I'm like, for what? I'm just an employee. What are you talking about?
Right.
One of the things I would think about doing, I hate to say
Yeah.
this, I'd be thinking about talking to a lawyer to sue
Right.
my
But here's
employer to
but here's the
indemnify
thing.
the thing that they should have told me, hey, we got to make sure this is in compliance.
Right. But here's the thing, Anthony, you were just given your example. Think about an American living in France who is working for a French company and who has signatory authority over accounts at that French company. Well, that French company is not necessarily going to even know that that American that they've hired who has signatory authority needs to send in information vis-a-vis via the FBAR to FinCEN in the United States. They might not even be aware of it or even know to even ask the question. You see what I mean?
Keith, that is by far the more common fact pattern. I think that someone is just the business manager, a U.S. person, whether a green card holder or a citizen, is an expat overseas, and they're working. I'm the controller of this company, and they're just humming along and getting all their things done, and no one bothered to check to see if they actually needed to file an FBAR, because you could really see how that could happen. Because imagine this company it's a French company. There's no foreign shareholders. There's no reason why this French company would look to U.S. tax compliance to say, oh, hey, let's make sure that we have everything, I'll say here.
Right.
There's no
and you know what?
say, boom.
Yeah. Right.
Yeah.
And you know what sometimes happens is that American who has signatory authority may find out, oh, wow, I'm supposed to file an FBAR. So he or she has to go to their employer and explain the situation to the employer. And the employer is just like, you got to be kidding. You see what I mean? So oftentimes it's the American employee that identifies that they need to do that first. So there's a lot of non-communication there.
Well, all right. Well, this is incredible. So I think that, so I think our bottom line here, tell me if you agree, gentlemen, we could expect FBAR enforcement to get even more intense, because the IRS doesn't like to lose. And they feel like they lost here. And I think they're just going to be taking it out, because you got to think here. Why would the IRS want to assess a $4.2 million penalty? Why? Why would you want to ruin someone who just was missing a form? Punish them more than anybody in the world would be punished. These are the craziest civil fines that you have, as if these people have done something completely malicious that hurt people. These people didn't hurt anybody. They just didn't know about a form. Yet we have an IRS out of control. So, John, do you think it's going to get better or worse on FBARs? Do you think? What do you think? The IRS is going to back off? Do you think they're going to double down or get a little nuttier?
No, they're clearly going to get a lot worse. And I think what's important for people to understand is that FBAR penalties it's really a civil forfeiture on steroids, right? I mean, mostly with civil forfeiture, they'll just take the asset. But, FBAR is a wonderful thing, for the United States generally, because it allows really the confiscation of assets, in a way that is done from their point of view in sort of a legal way. I think there's absolutely no doubt that the enforcement is going to get worse. And I think that this is actually a reason why, it's funny. When I read the Bittner decision, initially it was sort of euphoria, because I've been following the case for a long time. And I thought, wow, this is a win. Then I went back and read it a couple times and, got thinking about it again. And actually, after having read it, particularly the dissent, my advice would be, this is the best argument for renouncing citizenship I've seen in years.
Yeah, they are really going out of control. That's not really an option for a lot of people who are, but if you are overseas, maybe for people overseas to say,
absolutely.
It's definitely.
It's a problem, right? It's a problem, particularly given that really I mean, you can either view this as a 5-4 win for Bittner, or you can view it as a 7-2 loss for the average taxpayer. Because 7 of the 9 justices restricted, maybe this is all they felt they had to do, but they restricted their analysis to not the overall fairness and due process issues or anything like that, but just, well, what does the statute actually say? In 5, and nobody knows what it says. That's the biggest problem, right? That you can't even get agreement on what it says, these great penalties notwithstanding, and all it means is that 5 of them decided that the more reasonable interpretation based on everything was perform, and 4 of them said no per account. But all of them agreed, okay, that their job was, not to, look at FBAR in a broader context at all, but just what does the damn thing say? And that's what's so frightening about it, right? Because during the oral argument, a few times at least, there was agreement that all Treasury would have to do to justify imposing these penalties just change the regulations to some degree, right? Or Congress changed the law. So, I mean, I don't know what's going on in the discussion of, these people, the FBAR enforcement unit, what they're talking about today. But, in a lot of ways, I think they may be angry at the result of this particular set of circumstances, but I think this really clears the path for, some pretty significant enforcement down the road. And definitely, I think it's going to make them much more inclined to just assert willful penalties, right? Absolutely. And by the way, one other aspect of asserting willful penalties is, remember this, reasonable cause is not a defense. It's not a defense. Okay? So,
right.
Yeah, it's only a defense in the civil context. It's only a defense, right, in the civil side. So what happens is they assert the willful penalty. Well, the courts have held that's a question of fact. So you have to go to trial to determine whether it's willful or not. But if it's willful, then you don't even have a reasonable cause defense, right? So, I mean, this is, if I were the IRS, I would probably be irritated. But I would think, well, on balance, the news isn't bad at all.
Yeah. All right. Well, I thank you so much for your article, John. Thank you guys so much for joining me. And I think this is really, it's fascinating what's happening. And by the way, I want to give a shout out to Justice Jackson, someone who I wasn't really impressed by at her confirmation. She ends up again being one of the more intelligent justices on this issue. So congratulations to her.
Well, Anthony, you heard the oral argument. I mean, she was absolutely.
Well, I did get excited by her. I remember during our podcast, I was like, "Wow, she seems a little bit more smart." I was like, "Is she really going to be smart?" And yeah. So hey, hats off. That's awesome.
Yeah. So
now,
if Gorsuch and Jackson, right, were the two who,
right?
Hey, we need to look at this in a broader context, and also remember, Anthony, that Gorsuch, when the Supreme Court denied the cert petition in Toth, was the one justice who wrote separately saying, "No, this is garbage. Okay, we should be taking this on." Right. So, I think that
people not looking so good. Justice Thomas, ooh, big failure, buddy. Big failure. Really, you let everybody down, and this is a tarnish on your legacy. And they're not even looking at the statute. They don't even look at what it says. They look at the regulations first, which currently the regulations don't bear a strong there's not much of a relationship between the regulations right now and the statute. And, there's not much concern. So I want to end here. And this is really where I would say is like, make sure this would be my call to action to everybody watching this. You got to make sure your FBARs, all of your FBARs are done. And by the way, the IRS takes a broad interpretation of what a bank account is. Things that are definitely not bank accounts, the IRS considers to be bank accounts. So you want to make sure you have all your FBARs done correctly. And you want to make sure if you have employees that if there's FBARs for them, or if you're an employee yourself, that your FBARs, then you have a frank discussion with your boss. And if you're wondering about whether or not you are in compliance, you can reach out to my office at IRSMedic.com. If you run a business and you're wondering it's worth it to be a U.S. person or not, maybe it's time to, as John said, renounce your citizenship, I would suggest reaching out to John to get that process going. And his email will be in the description below. And if you have those questions that maybe an attorney can't answer, and those actually do exist, then I would suggest reaching out to Keith to get sort of, what are some of the options that you have. And Keith is really in tune to what other people are doing to allow you to know, make what the best decision is for you. So with that, I just really, really want to thank Keith and John for this. This is a case we've been following. I'm happy for Mr. Bittner, but I am disappointed, shocked, not shocked. No, I'm disappointed, predictably disappointed. Maybe there's a German word for that. Is there a German word for predictably disappointed? That is where I am. So with that, I want to thank you all for subscribing, and any questions that you guys have about the FBAR, if you have anything, just leave those in the comments below. I'll be happy to answer them. And this is Anthony Parent for John Richardson and Keith Redmond. I thank you for watching.